On April 29th, the Supreme Court handed down a major decision that could change how congressional districts have to be drawn. The case was concerning a recently drawn Louisiana district that winded its all the way from Baton Rouge to Shreveport in order to ensure it was majority-minority. The Supreme Court ultimately decided that this congressional map was a clear racial gerrymander and violated Section 2 of the Voting Rights Act of 1965. Now, if you look at many media sources, it'll look like the Supreme Court just said that black people are no longer allowed to vote, but an obvious partisan exaggeration completely misses the point. So let's look deeper into the decision. The decision was made 6-3 with Justice Alito delivering the majority opinion, with Justices Roberts, Thomas, Gorsuch, Barrett, and Kavanaugh in support, with Justices Sotomayor, Kagan, and Jackson in dissent. Alito begins by saying that the lower courts have sometimes used Section 2 of the Voting Rights Act to engage in the very race-based discrimination that the Constitution forbids, essentially gerrymandering districts to hand small pockets of black voters the representative of their choice. One issue that this case in Louisiana brought up was an issue of predominance. Was race the predominant motivation in the state's decision-making process? Alito also points out that another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, we have assumed for the sake of argument that the answer is yes. But allowing race to play any part in government decision-making represents a departure from the constitutional rule that applies in almost every other context, ultimately concluding that compliance with Section 2 could not justify Louisiana's use of race-based redistricting in this case. Alito's defense begins with the 15th Amendment, saying that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on the account of race, color, or previous condition of servitude. Acknowledging that states did suppress the rights of black citizens to vote, using different methods like poll taxes, property qualifications, as well as districting schemes to prevent the election of black candidates and candidates that black voters preferred. Section 2 of the Voting Rights Act was enacted to forbid these practices, and simply said that no voting qualification or prerequisite to voting shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on the account of race or color. Integrating black voters into majority white districts does not inherently prevent them from electing black candidates or electing their preferred candidate, as the dissent and media might have you believe. What it is talking about is specific motivated targeting of black voters, essentially the reverse of what's happening in Louisiana. However, in the 1980 Mobile v. Bolden case, the court's plurality decided that facially neutral voting practices violate Section 2 only if motivated by a discriminatory purpose, and that a redistricting practice, even if motivated in part by race, would not violate Section 2 so long it was supported by valid and articulable justifications. Building on that case and others like White v. Register and Thornburg v. Gingles, the court modified the discrimination framework for racial gerrymandering cases. Although any use of race in government decision-making generally triggers strict scrutiny, in gerrymandering cases a challenger must show that race was the government's predominant consideration. And in cases where race predominated, states would sometimes assert that compliance with the Voting Rights Act provided a compelling interest in justifying the use of race. But Alito then spends the rest of the section going through relevant cases to show that the court has never decided that compliance with the Voting Rights Act was a compelling interest. It had only been assumed. That moves us to today, and the decision in Louisiana for the intentional creation of a second predominantly black district, to which Alito says that Louisiana's intentional creation of a second majority-minority district had been prompted by an order, suggesting that such a district is required by the Voting Rights Act. Our question necessarily implicated the correctness of our long-standing assumption that compliance with the Voting Rights Act may justify what the Constitution generally condemns, the use of race as a basis for government action. To which he swiftly responds with that we start with the general rule that the Constitution almost never permits the federal government or a state to discriminate on the basis of race. Current legal precedent only provides two reasons that satisfy the strict standard. One is for avoiding imminent and serious risks to human safety in prisons, such as a race riot, and the other is remediating specific identified instances of past discrimination that violated the Constitution or a statute. Obviously, the first isn't relevant to this case, but the second must then meet two criteria. First, the discrimination must be identified discrimination. Second, after identifying the specific instance of discrimination, the institution that makes the racial distinction must have a strong basis in evidence to conclude that its remedial action is necessary. This is a tough sell when it comes to voting, as Alito quotes from the Shaw case, where the state assumes from the group of voters race, that they think alike, share the same political interests, and prefer the same candidates at the polls. It engages in the same racial stereotyping at odds with equal protection mandates. Justice Alito then moves into breaking down the text of the Voting Rights Act itself, and I'm spending a lot of time on Alito's decision because only one concurring justice gave an opinion, which was Clarence Thomas, and it was 2 paragraphs. So starting with Section A, Section 2 of the Voting Rights Act says, "No voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, as provided in subsection B." Alito says that a legislative districting map constitutes a standard practice or procedure because if it didn't, all the previous vote dilution cases would have been completely baseless. Therefore, subsection A means that a districting map may go against Section 2 if it results in a denial or abridgment of the right to vote on account of race or color. And with that, we have to move to Section B to explain. I think just reading it first will be helpful. A violation of subsection A is established if, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A, in that members have less opportunity than other members of the electorate to participate in the political process and elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population. The main discussion is what less opportunity than other members of the electorate to elect representatives of their choice really means. To the court, opportunity must mean a chance to achieve a desired result, because the Voting Rights Act does not guarantee equal outcomes, so less opportunity means a lesser chance. Alito provides the analogy that men under 6 feet tall have less opportunity to play in the NBA than those who stand at 6'7", the current median height. The next part, other members of the electorate, has to be a group of voters used as a comparison to determine whether the legally protected group per subsection A has actually suffered or is threatened with suffering less opportunity or vote dilution. And finally, to elect just means electoral victory by casting ballots. The point of this clarification is to set a baseline for what less opportunity is and is not practically. A Republican voter in a largely Democratic district will have a low chance of winning the election for his or her preferred candidate, just like a Libertarian voter would in a largely Republican district. But that does not imply discrimination. Voters who end up in a given district depend on the districting criteria used by the state in drawing a legislative map. The Constitution does not necessarily prevent states from using ideological criteria for drawing districts, because ideology is not an immutable characteristic, but it does specifically prevent the use of certain criteria like race. The opportunity of these members of the electorate to contribute their vote to a winning cause is whatever opportunity results from the application of the state's combination of permissible criteria. This is what a randomly selected individual voter and group of voters can expect regarding their opportunity to elect a preferred candidate. And under Section 2, a minority voter is entitled to nothing less and nothing more. Justice Alito continues by emphasizing the 15th Amendment's purpose to prohibit intentional racial discrimination, and differentiating how districts drawn for partisan purposes are different from districts drawn for racial purposes. If a state defends a districting scheme on the grounds that it was drawn for partisan purposes, plaintiffs have a special burden to overcome, and the plaintiff must disentangle race from politics by proving that it was the former that drove a district's lines. Basically, it must be clear that the district was drawn on racial lines and not political lines. The last part of the majority opinion I'll cover in this section are the 4 historical developments noted since the original Gingell's decision 40 years ago, and how it should affect the framework of the legal precedent. First is the vast social change that has occurred throughout the country and particularly in the South. At the time of the passage of the Voting Rights Act, the nation had faced nearly a century of entrenched racial discrimination in voting, but there were great strides in the ensuing decades. Voting tests were abolished, and disparities in voter registration and turnout due to race were erased. Black voters now participate in elections at similar rates as the rest of the electorate, even turning out at higher rates than white voters in 2 of the last 5 presidential elections. Second, Gingell's arose in the context of a one-party system in which black and white voters had starkly different voting patterns despite their affiliation within the same party, where even in heavily Democratic areas, white voters often ranked black candidates last among Democrats. These intra-party disparities showed that black voters had less opportunity to elect their preferred candidate because of their race, not because of their partisan affiliation. We don't see that anymore, and in a state where both parties have substantial rapport, with race often being correlated with party preference, a litigant can easily exploit Section 2 for partisan purposes by repackaging a partisan gerrymandering claim as a racial gerrymandering claim. The third development was the court's decision in Rucho v. Common Cause in 2019, which in essence says that claims of partisan gerrymandering are not justiciable in federal court, and a state's legislature may use partisan advantage as a factor in redistricting. Because of this, jurisdictions in which race and partisan preference are very closely correlated would provide a convenient way for future litigants in lower courts to sidestep the decision in Rucho. This is why there must be a clear distinction or disentanglement between partisan gerrymandering and racial gerrymandering. The last development is simply technology. Computers are now used to create thousands of potential district maps, and with the easy ability to control for a number of redistricting factors, if it is possible to identify an alternative map that fully achieves all of the state's legitimate goals while promoting greater racial balance, then a Section 2 plaintiff can easily do that themselves. Now, the last sections cover specific changes to the Gingell's framework, more specific application to the Louisiana district map, and rebuttals to the dissents. But I think that really covers what matters for Justice Alito's majority opinion. I will quickly go over Justice Thomas's concurring opinion since it's very short and straight to the point. He says that the court should never have interpreted Section 2 of the Voting Rights Act to effectively give racial groups an entitlement to roughly proportional representation. By doing so, the court led legislatures and courts to systematically divide the country into electoral districts along racial lines. Blacks were drawn into black districts and given black representatives, Hispanics were drawn into Hispanic districts and given Hispanic representatives, and so on. That interpretation rendered Section 2 repugnant to any nation that strives for the ideal of a colorblind constitution. He says he would even go farther and say that Section 2 of the Voting Rights Act does not regulate districting at all. How states draw district lines does not fall with any of the three categories of actions states are prohibited from imposing or applying, which are voting qualifications, prerequisites to voting, or any standard practice or procedure that results in a denial or abridgment of the right to vote based on race. Therefore, according to Justice Thomas, no Section 2 challenge to districting should ever succeed. On to the dissenting opinion, Justice Kagan wrote for the minority, and while it was longer than the majority opinion, I'll admit it was a little harder to parse out specific arguments because her dissent reads more as a winding, lamenting narrative than a much more structured, argumentative opinion from Alito. The entire dissent ultimately relies on what equal voting opportunity means. She argues that outcomes are what matters, not intentions, and that the 1982 amendment to Section 2 allows for an effects test, instead of requiring a plaintiff to prove intent. An interpretation the majority said was assumed in decades since due to largely social factors and attitudes, but which Kagan and the dissent claim was decided precedent. The underlying theme of the main claim seems to be that if states don't make minority-majority districts and essentially hand minority voters the representative of their choice, then they don't have the same opportunity as everyone else because integrating with other groups will dilute their success in electing their candidate. And updating the Gingell's framework from outcome to intention makes an already difficult case basically impossible to win. So long as the map makers can make a partisan argument, they could cover for racial intentions, and thus the law is dead. I know I had to spend much more time on Justice Alito's majority opinion compared to Justice Kagan's dissent, but really the crux of the dissent was the interpretation of equal voting opportunity and the dispute of precedents in cases like White and Allen. And if you read media outlets from the left side of the aisle, the common idea is that if minorities don't get their own special voting districts, then they don't have voting rights at all. You can't just isolate and hand black voters their chosen representative today because of past discrimination. Modern injustice is not the solution to past injustice, and the Constitution makes it very clear that you can't discriminate against or show favor to people on the basis of race. I thought non-racial substantive representation was the goal, not hyper-racial, forcibly proportional descriptive representation. All that does is force people to turn to their own race for representation and force increasingly distinct racial voting blocks. Kind of goes against the entire point of the civil rights movement, I think. The problem with the outcome-based interpretation is that any observable difference in outcome could force a claim of discrimination. There's a reason why we don't allow every black job applicant who gets turned down in favor of a white person to sue for discrimination. The black applicant has to prove that there was a racial motive in the hiring process. Intention is what matters, not the outcome, and democracy should not guarantee any outcomes. Some final thoughts are that, in reality, it's hard to tell how much this ruling will actually change maps. Because of how minority voters, especially black voters, vote so similarly, states could essentially draw the same maps and use partisan rationales instead of racial rationales, and basically get the same results. I thought the entire point of racial progress was to look at voters based on political beliefs anyways, not on skin color. That's all this ruling lays out. You can't draw congressional districts to favor voters based on race. And also, I don't think less likely means less opportunity. We all have the same opportunity to get into the NBA, but being 5'10 is definitely less likely for me to get in. That doesn't mean that the NBA is discriminating against me. And there are increasing numbers of black representatives from majority white districts as well. As Justice Alito alluded to, Representatives Amelia Sykes, Wesley Hunt, Lauren Underwood, Burgess Owens, and John James are just a few to name. So the idea that if you get rid of specifically black districts, we won't have any more black representatives is demonstrably false. I get that critical theorists have maintained racial identity as an important paradigm to pit groups against each other for their own political gain, but some of us think that people should be looked at by their interests, and voters should be looked at by their political interests. That way we can integrate instead of segregate, and have meaningful debates and discussions instead of annoying name-calling and character assassinations. Thank you for watching. Let me know what you think about the ruling and redistricting going forward. If you enjoyed, don't forget to like and subscribe, and I'll see you in the next one.